Welcome to the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar.
Thank you for tuning in for this edition of the New York City Bar Association podcast. My name is Dwayne Amos, and I'll be your host. I'm a member of the New York City Bar Association's Entertainment Law Committee, where I serve as the chair of our litigation subcommittee. I'm a senior associate at Coates LLP, and my practice focuses in complex commercial litigation. We have an exciting show for you today. Today's episode is a collaboration between two New York City Bar Association committees, the Copyright and Literary Property Committee and the Entertainment Law Committee. The Copyright and Literary Property Committee sits at the center of the biggest issues shaping today's creative industries. The committee tracks cutting-edge developments in copyright law while bringing together practitioners and industry leaders for timely conversations on the future of creativity, technology, and intellectual property. The Entertainment Law Committee brings together practitioners from across the film, television, music, theater, and digital media industries to tackle the legal issues driving today's entertainment business. Today, we're diving into one of the most important and increasingly consequential divides in modern copyright law. That is, the differences between how the Second and Ninth Circuits analyze copyright law. We'll look at two modes of analysis: substantial similarity and the server test. These aren't just academic distinctions, they shape litigation strategy, forum selection, free speech considerations, platform liability, and ultimately, the scope of copyright protection in our ever evolving digital age. We are joined today by an incredibly distinguished panel of industry experts. These panelists are not just academic experts. First up, we have Barry Werbin, Counsel at Herrick, Feinstein LLP, and a highly respected leader in intellectual property and technology law. Barry's practice spans copyright, trademark, online and digital rights issues, among other areas. Today, Barry will be focusing on substantial similarity analysis in the Second Circuit. Welcome to the podcast, Barry.
Well, thanks very much. I'm real happy to be here.
It's a pleasure to also welcome Aaron Moss to the podcast. Aaron is a partner at Mitchell Silverberg and Nupp LLP and one of the country's leading voices in entertainment and intellectual property litigation. He represents major studios, media companies, and creators in high-stakes copyright, trademark, First Amendment, and AI-related disputes. He is also the author of the very widely read and highly respected legal blog, Copyright Lately. Today, we'll be leaning on Aaron for his experience with substantial similarity analysis in the Ninth Circuit. Welcome, Aaron.
Good to be here. How you doing?
Good. So, let's set the stage and start with some basics. While there isn't necessarily one quote-unquote substantial similarity test, can you explain for our listeners what we mean when we say substantial similarity in the context of copyright litigation?
So first, let me say, Aaron and I, despite being on opposite coasts, in the past, we've actually worked very close together on the same side. So this is like a friendly boxing match here. But I thought, this is a free-willing conversation, but I think the perspective for all our listeners is important to understand. Why are we in this situation before we talk about what different tests are coast to coast? The problem we start with is that neither the 76 Copyright Act nor the 1909 Copyright Act contain any definition or test for infringement. The 76 Act merely says in Section 501, anyone who violates the exclusive rights of a copyright owner is an infringer. And similarly, in the 1909 Act said if any person infringes the copyright, such person shall be liable. Not very helpful. So starting back in the 1940s with Feinstein v. Porter, which is really the seminal Second Circuit case, it still has viability today. Courts had to create some test for what did these words mean in the statute. The closest, I think the Supreme Court has ever come was back in 91 in the Feist case, which of course told us facts aren't copyrightable and got rid of the sweat of the brow. But Feist said a plaintiff in a copyright case to establish infringement must prove two elements. One, ownership of a valid copyright. Well, that's fairly straightforward. And two, copying of the constituent elements of the work that are original. So everything is packed into that second test. So copying, well, first you have to assess copying, right? So I think in the Second Circuit, starting with the Arnold Ornstein case and carry forward to present with variations, the Second Circuit says, okay, well, you have to prove access plus substantial similarity. How do you prove access? Well, in the rare case or the occasional case, defendant might admit access, right? Or there's clear evidence of access. A manuscript, a screenplay was mailed directly to the individual defendant. But more often than that, and I think we would all agree as practitioners, that doesn't happen. So you're relegated to circumstantial evidence of access. And here the Second Circuit considers what the court calls probative similarity. It's completely different than substantial similarity. And courts there can look at the defendant's alleged infringing work as to both protectable and unprotectable content and see, is there probative similarity sufficient to circumstantially imply that there was access? And of course, there are issues of fact, there could be expert testimony. If you get over that hump, then you get into the Second Circuit, sort of the main second factor, which is substantial similarity. And the general principle through the decades has been generally that's assessed from the point of view of an ordinary lay observer. But where you have protectable and unprotectable content, elements that could be barred by sens faire, by the idea expression dichotomy, common phrases and expressions, common tropes within works of art or literature or whatever, then the more discerning observer test comes into play, which basically means now you're parsing out the unprotectable from the protectable. But at the end of the day, normally a jury, as the trier of fact, if it's a bench trial, has to make the assessment as to substantial similarity. And the earlier cases with the Second Circuit have said you really shouldn't be using expert testimony. But as a practical matter, in my getting ready for this, you see more and more cases making exceptions where once you get through the access and probative similarity, courts will, in the Second Circuit, have no hesitation to grant a motion to dismiss or motion for summary judgment on substantial similarity, even to the extent of assuming, without deciding the issue conclusively, that there was access and probative similarity, and take that role on themselves to do that, which I don't think, Aaron, we regularly see as certainly as much in the Ninth Circuit. I'll turn it over to you.
Yeah. So thanks, Barry. And thank you all for having me. So the Ninth Circuit's test is, first of all, it's a bit of a mess. That's a legal term. And it's in a little bit of limbo, but I'll try to describe kind of how it exists now and how it came about. So we have a two-part test for substantial similarity that both parts need to be satisfied. We have an extrinsic test, which is an objective comparison where the judge will filter out unprotectable material. So anything like ideas, sens faire, public domain elements, and the court will ask whether what is left, the protectable elements, are substantially similar to corresponding elements in the defendant's work. And that can be decided as a matter of law on summary judgment. Defendants will sometimes, I think it's less likely nowadays, win on summary judgment, but disputed issues of fact go to the jury. Where it turns into a little bit more of a black box, maybe a lot more of a black box, is when you get to the intrinsic test. And that asks whether an ordinary reasonable observer would find the work substantially similar in their total concept and feel. And that is reserved for the trier of fact. No expert testimony is permitted. No analytic dissection is allowed there. The jury is simply told to compare their overall impression of the two works. And that test has been criticized for years. Most recently, and we'll get into this, I'm sure, in a bit, most recently by two high-profile Ninth Circuit judges in a case involving Kat Von D and Jeff Sedlick. This was the tattoo case of the Miles Davis photograph that Jeff Sedlick took. Kat Von D tattooed it onto her friend's arm, and Sudlick sued her for infringement. The jury, notwithstanding evidence that Kat Von D was really looking to trace it and have it be 100% identical to the photograph, found no substantial similarity. And it was essentially unreviewable because you had this amorphous concept and field test that really you could not look behind what the jury was doing there. And it's actually caused, in a concurrence to that case, two of the Ninth Circuit judges to call for a reconsideration, essentially saying that the total concept and field test ought to be scrapped because it really does not help plaintiffs. It does not help defendants. And we can get into some of those reasons why. But I think it is safe to say that we're in a bit of the limbo as we wait to see whether en banc review will be granted in that case and whether after 50 years, total concept and feel may be done with.
Right, right. And we will talk a little bit more ahead of us about, I think, that and sort of where things are heading and the implications for practitioners. But why don't we take sort of a step back and zoom out a little bit and talk a little bit about the practical differences that have merged between the circuits. And I think one thing that might be helpful is if we maybe take a look at the litigation cycle and how courts look at it differently. For example, you both sort of touched on how is it looked at the motion to dismiss stage, right? Things that are decided as a matter of law versus how it's looked at when it gets to the trier of fact. Aaron, you want to?
Yeah. So this is actually, I think, a key difference that may, if you have the ability as a plaintiff to determine whether you're going to file a lawsuit in the Southern District of New York or the Central District of California, you may actually make a decision based on the way that courts, certainly recently, have been looking at these issues on 12b6 motions. So it used to be that fairly routinely, district courts would, especially in cases involving literary works, things like screenplays, allegations that a movie infringed the plaintiff's script, cases like that where the works were before the court at the outset of the case and readily capable of being compared, they would do that. And then about 5 or 6 years ago, in a series of unpublished Ninth Circuit cases, the judges kind of pushed back on that and said, we really ought to be looking for experts to weigh in on this. We ought to be allowing discovery to be taken on these cases. And so the court, again, in unpublished cases, has reversed a number of those determinations where district courts had been throwing out these cases on 12b6 grounds. And since then, district courts have become much more gun-shy about dismissing cases or even comparing works at the 12b6 stage. So they still require, plausible allegations as opposed to conclusory allegations of similarity, but they are much more hesitant nowadays to actually do a deep dive or leave comparison. Some judges will do it, and there are certainly some cases where it happens and it's warranted, but by and large, it doesn't happen as much as it used to. And I think, Barry, you'll tell me if I'm wrong, but I think certainly in the Southern District of New York, judges are still willing to do that type of work.
Yeah, it's a great segue, and thank you. And you're absolutely right. I think most of the judges, certainly in the Southern District, which, along with maybe the Northern Central District, California, probably see the plethora of copyright cases, percentage-wise in this country, and the Second Circuit have no hesitation in, I'm not going to say taking it away from the jury, but essentially making the ultimate determination that no reasonable jury could find, let's say, substantial similarity, however you assess that. And I think it also makes an important difference, I think, both Ninth and Second Circuit and in any court, what kind of content we're talking about. Because, Aaron, you mentioned the easier case is something that everyone can relate to, judges, jurors, etc. are literary works, be it a book, be it a screenplay, etc., or a poem, and maybe art, similarly, because it is what you see in the Sedgwick case, right? Art and photography, although came out differently than a lot of us expected it would. But when you get into music, especially musical notation and software, there's no way a lay jury can assess what's protectable or not, and then make any rational comparison without expert testimony. And so over the decades, when we look at Ornstein Reporter in the older cases and even Ninth Circuit, where the intrinsic, extrinsic test kind of derived from I think it was under the 1909 Act, I forget that decision, courts have had to morph into the modern times to fit more unique scenarios that don't involve simple textual works. But courts don't shy away from that. So a couple of big examples, and I'll turn it over. The Second Circuit's Ed Sheeran case, which in 2024, which involved found his thinking out loud did not infringe on Let's Get It On, the case he won. The Second Circuit had no hesitation in that case of finding that, quote, finding that no jury could find as a whole that the two songs were substantially similar, and that the melody or lyrics of Thinking Out Loud had any resemblance to those of Let's Get It On. The court goes through analysis. And I don't think in the Ninth Circuit you would ever see a district judge. I think today, would be much rarer to see that. And a decision I just found last night came down the Southern District in just March, a few weeks ago, where the Judge McMahon, involved a plaintiff alleged that her unpublished drafts of a novel involving some phantasmagorical story about a girl who went to high school in Alaska, had paranormal things embedded in her, didn't even go to the jury, was appropriate to decide on summary judgment motion. And the court, the Judge McMahon, and presumably his law clerks, reviewed some 6,000 pages of drafts, comments and questions through drafts. The defendants included a New York Times multiple best-selling author and her publishing companies, an agent. And the court, I can't even imagine the scores of hours the court spent doing what a jury would normally do, and concluding that once you strip out unprotectable aspects like sins affair and common tropes, etc., there's no substantial similarity as to what was left minimally in common. And even there, the court acknowledged that while the Second Circuit says the court invoked the stringent observer test, but even there, you're not supposed to consider expert testimony. But there are exceptions, said the court. And here, the court allowed limited expert testimony to be considered on the issue of, in this type of literature, with like supernatural romance novels or whatever they called it, certain tropes were very commonplace in that genre, which a jury or a trier of fact, the court in this case, could not know or assess on its own from merely reading the work. But the court says that's the only expert testimony we're allowing. So we see cracks even in the Second Circuit cases, where certain types of cases you may have limited expert testimony, even though if you go back to Ornstein and Porter, it says you're not supposed to consider expert testimony. And certainly with music and with more technical things like software, where there's very special tests, in the Second Circuit Altai case, a whole different mix.
Yeah. And look, I would say that it is not universal that the Ninth Circuit will not kind of jump in and serve a gatekeeping role, although sometimes that does not take place until after a jury has already come in with a verdict. So a good example of that was the Katy Perry Dark Horse case, and you had a judgment notwithstanding the verdict, or judgment as a matter of law, and the Ninth Circuit said, yeah, what we have here are common building blocks of music that are unprotectable, and so no reasonable jury should have been able to find a similarity based on that. And this is one of the reasons why plaintiffs don't particularly like total concept and feel is kind of a test that everybody loves to hate. But the reason that plaintiffs don't love it is because, if you have a situation where the jury comes back and says no substantial similarity on a total concept and feel, it's essentially unreviewable, as we saw in the Sedgwick case. Whereas if the jury says that there is substantial similarity, there is the ability for the court to say, well, was that based on a review of protectable elements, or was it just unprotectable elements? And they can jump in and course correct if they need to, and they have. The reason why defendants don't particularly like it is because, assuming that you do filter out savoir-faire and ideas and public domain material at the outset, but you still go to the jury, there's really no way to ensure that the jury is not kind of importing a lot of that stuff back in when they're doing this black box analysis. And just the very name of the test, total concept and feel, it kind of tells you what you need to know. I mean, concepts are not protectable, and yet here we have a test that is designed for lay jurors to be making these analyses that are really based on, I think it's probably the copyright equivalent of I know it when I see it, and it's not all that satisfying for defendants either.
Right. Yeah, this really timely, Aaron and Barry, and we can see from what we're seeing with Sedlick, which is that I think the body of law and the paradigm that's shaping is really happening in real time and unfolding, and we're sort of on our edge of our seats and waiting to see what the Ninth Circuit is going to do there. And let's
There's one thing I just want to say that you switch because it's important. Something Aaron said. The Second Circuit also evokes total concept and feel, but I think it approaches it in a different way. It's total concept and feel along with, in the case of literary work, themes, characters, plot, sequence, pace, and setting. It's not sort of this, I don't think it's this abstract setting. We just throw it all to a jury and they have to say, okay, well, it looks and smells similar. But I just want to make that clear because you see that in Second Circuit. You see total concept and feel come up in a lot of Second Circuit cases.
All right, and we're privileged to also be joined today by Marc Lebowitz. As principal of Lebowitz Law Office, Marc has been practicing media and entertainment law in New York for over 30 years. He represents media companies and online publishers in all aspects of their business and has had a litigation-focused practice with a focus on media, publishing, and entertainment matters. Marc will be serving as our panel expert on the Second Circuit's application of the server test. Welcome, Marc.
Thank you. Thanks for having me.
And finally, we're joined by James Bartolomei. James is of counsel at Duncan Firm, PA, and a veteran litigator whose practice sits at the intersection of copyright law, entrepreneurship, and emerging technology. Like our other panelists, James could speak to a wide breadth of issues, but this afternoon we'll be particularly interested in his expertise with the Ninth Circuit's application of the server test. Welcome, James.
Pleasure to be here. Thanks for having me.
James, why don't you explain for the listeners, what is the server test and how is it developed across the circuits?
So, thank you for having me on today. It's no surprise, given my background, that I represent content creators, that the server test is more or less a made-up judicial doctrine that does not follow the plain text of the Copyright Act and was born out of some of the early tech companies' growth out of Silicon Valley, and really for a way for tech companies who are building online service platforms or OSPs, I mean, depending on what you call them, internet service providers or online service providers, where they're basically building the town square or the platform for their users to populate the platform with content. And in order to expand their reach, they had to figure out a way that would allow them to more or less provide immunity that they would not be liable, or folks that were using the content on the site to be liable for the display and copying of those copyrighted works that were often put on there by users. So the server test was born out of a case called Perfect 10, and more or less stood to the proposition that Google was indexing copies of copyrighted works, and they were porn videos. And at the end of the day, you had to look at the case through the lens of fair use, but you also had to look at it from the perspective that the copyrighted works themselves were not necessarily stored on Google servers. Oh, Google was the intermediary between whoever was infringing and the copyright owner. And ultimately, the court found that because Google wasn't storing a copy of the copyrighted works, they couldn't be found violation of any of the exclusive bundle of rights, including the display right. So, that case was 2007, and here we are almost 20 years later, and it's still good law in the Ninth Circuit. In fact, I attempted to challenge it on a class action level against Instagram a couple of years ago, and ultimately what it comes down to is a judicial doctrine that allows an alleged infringer to say, if I didn't keep a copy of the copyrighted work on my server, you can't get me for violating or infringing someone else's copyright. That's sort of in a nutshell. I'm sure Marc maybe has a little bit of a different spin on what the test represents, or the doctrine represents, but it's judicially created. It's not doctrinally consistent with the plain text of the Copyright Act.
Well, I mean, look, I'm here in the Second Circuit where it hasn't been followed. I represent publishers and I also represent content creators. So I'm not for the Wild West of anyone's content being able to be taken, but I have been working with companies who are really on the forefront of technology and publishing. And, I come at the server test from the issue of embedding, right? Which I think we here are familiar with it. It's when you provide code on a website, which then takes you to another server and another website to view content. And specifically, there are a lot of cases in the Second Circuit that wrestle with whether an embedder is a copyright infringer and whether a party, a plaintiff who puts up content on their social media and makes it public and affirmatively says this may be embedded and signs on to the terms of use. And the main social media platforms have similar but not identical terms of use. And that's become relevant in the decisions that have come down, mostly in the Second Circuit, interpreting which of the terms of use provide a valid sublicense to an embedder. But the server test is a way where you would sort of nip that issue a little bit closer to the tree. So when parties embed, they're saying, and they're agreeing to terms of use, and X's terms of use specifically say, and I wrote it down here, this license authorizes us to make your content available to the rest of the world and to let others do the same. So without the server test, if the server test applies, then if a client embeds someone's X post on a sports website, then they are not displaying it for purposes of the act. And that predicate element for copyright infringement doesn't exist. If it is a display, and in the Second Circuit, certainly it's a better argument now that it is a display, although there has been no Second Circuit Court of Appeals decision. There have been a bunch of district court decisions that have either nodded at the server test and said, we decline to adopt it here, or have said simply, the display issue is not before us. I'm ruling on fair use, so I'm not going to address whether the server test applies in the Second Circuit. And recently, the Second Circuit Court of Appeals got a case, but display was, I think, acknowledged in the case. So the Court of Appeals said, but we know it's an issue as to whether the server test applies, but we're not going to address it. And there have been one or two cases where a court, if you want to believe it might not be applied in the Second Circuit, where courts have said that they may or may not apply it. But there's only been real specific, firm statements by district judges that it doesn't apply. And I would say, James, if you'd agree, there have been a couple of sort of less definitive, I'm not going to reach it. Maybe it does, maybe it doesn't, which would give some people the ability to think, maybe it won't apply. But in the context of social media posts and specifically embedding writers, photographers' posts, from my perspective, there's a real problem out there and there's real room for mischief when the server test doesn't apply. And that is content creators, we'll call them, writers, photographers, put up content and posts on their, let's use X as an example, on an X feed. And they put it up there to be picked up and linked to. And that's how they make money. They get the credit for the views. It's not, whoever has embedded it is not getting credit for the view of that post. It is going back to the server where it's displayed. And these content creators will then pick and choose some people who have embedded it and sue them. And they don't send a takedown letter. There's been no case that says, the DMCA takedown requirements apply. So what happens is, and what happens to clients that I've dealt with is, you get a letter saying you owe me whatever, $75,000, $15,000, $30,000 because you embedded my posts. And then if you are a careful publisher, you will then immediately take it down or disable the link. And then what will happen is simply a black square will appear on your website because lo and behold, you weren't displaying it. It was being displayed at some other website. And if you disable the embedding code, then there's just a black hole there. And also, if the plaintiff had simply asked the host to take it down, a black hole would appear on your screen as well. Or if the plaintiff had simply said, I'm not going to upload this with public rights for anyone to embed, then you wouldn't be able to embed it. So what's happened with a lot of these cases, and I'm sorry if I'm rambling on a little bit, moving off the actual server test, but what's happened with these cases is there's an ecosystem of embedding these articles which benefits the people who put them up, but they're able to pick and choose people to sue and stick up for money. And as we all know on this call, the economics of a copyright case over a $7,500 license makes it so you never get to the Second Circuit. So what we have in the Southern District is scores of cases where there's wishy-washy language on a motion for judgment on the pleadings. There's some specific language. There's a fair use ruling because the judges realize the server test doesn't apply. And then some judge overreaches and says, well, if it's embedding, it's automatically fair use. We've seen that. And we have a very uneven and hard to predict state of the law in the Second Circuit. And in my opinion, I think the server test is an appropriate test to use. And I think it allows control for the party uploading the content. You decide if you want it public. You decide if you want to allow embedding. If you want to ask someone to take it down, even though you've allowed embedding, you write them a letter. And if they take it down, they take it down. But at this point in the Second Circuit, I don't know if we're going to get a decision. And as you know, the Supreme Court recently refused to hear, you were just mentioning this, and really there's no split in circuits yet. I don't know, I try to read into it. I think it was the Mediaite decision in the Second Circuit, which recently said, we're not going to reach the server test, I think is encouraging because they didn't nod and say, as we all know, the server test doesn't apply here. And the Supreme Court has said, we're not going to review it because there's no split in the circuit. So I think it's hard to know which way it's going to go. But speaking on behalf of publishers, and I don't only represent publishers, but taking this argument on behalf of publishers, I think there's a lot more certainty in the Ninth Circuit. It allows for the economics of receiving credit for your content if it's still hosted where you put it up. It allows for that all to continue in play. And I don't know what's going to happen in the Second Circuit, but something's going to happen.
So let me ask you, James, because you gave us a bit of, sort of the high level overview, but can you tell us a little bit more specifically about how it's living in the Ninth Circuit and what should practitioners expect or what do they need to know about litigating, dealing with server in the Ninth Circuit?
Well, that's a great question. And as a practitioner, if I'm faced with advising a client, which I think for the listeners that are listening to this podcast, rather than just focus on the academia of what this district court's going to do or that district court's going to do or that appellate court's going to do, it is if I've got a client that's faced with maybe looking at having an infringement that butts up against the server test, and they have no venue to choose from except the Northern District or the Central District of California or one of the district courts in the Ninth Circuit, I'd say, no, don't file that case. Go look for a better place to file. I think everything that Marc mentioned really ought to be looked at when it comes to how clients ought to evaluate the economics of a case is, first, was the use fair use? Is there another defense out there such as a license? And I don't know that there's a one-size-fits-all when it comes to social media embeds when it comes to, for instance, a license defense. So the short of it is, if you have a client that has to face pursuing their rights, and the only place to go is going the route of a Ninth Circuit court, unless the law changes, I'm probably not going to advise that client to pursue that case. Although one other point in terms of us all wanting clarity in the law, because as lawyers, we're typically only making money and generating compensation for our clients, if that's what the goal is. from the plaintiff's perspective, if you're seeking money damages, is if there's conflict. And right now there's still conflict where you've got the Ninth Circuit and you got everybody else. But there is, breaking news for the audience. I'm not sure when this podcast is going to be aired, but on June 1st, the Emmerich newspaper versus particle media case is going to be orally argued. And it is directly addressing the issue of a media company that is creating original content, and one of these web scrapers is going through and causing a display of Emmerich's articles on the particle media app. It's causing a display, but the copy is residing with Emmerich's newspapers, and that case is going to be heard, and it's fully briefed. I was just looking at it before we had this call today, is that could very well address an issue of a circuit split. And, will the Supreme Court take it up? Will they have an appetite to, look at look at the law in terms of the plain language of the Copyright Act versus let's just try to get rid of liability for a whole broad scope of, tech companies that allow their users to embed content in a way that denies copyright holders, fair compensation, assuming there's no license and assuming that, fair use doesn't apply, which unfortunately Marc had mentioned.
Well, James, the server test doesn't only protect big companies.
No, but it protects every.
It doesn't only protect big tech companies. The application of the server test, I think, inures more to the benefit because those companies have other protections that they can rely on. I see the application of the server test inuring more to the benefit of small publishers who are using embedded links as part of their articles and reporting, and send people back to original content that's posted by others and uploaded for sharing on social media sites. I see more room for mischief, and well, maybe it's because I've seen more mischief going in the other way, which is people by design putting things up to be shared and then bringing, massive, many lawsuits against people and just sticking them up because it's a federal case in federal court. And it's not cost effective to litigate a case that someone's going to settle for $7,500 or $12,500. And in my opinion, that's why we don't have any clarity in the Second Circuit, because all these Southern District of New York cases, mine, which settled after conferences with Hellerstein, I've had dozens of them. Yours, where you won cases and then the case goes back to court and 6 months later, it just settles. And it's confidential and it's gone, and you have this judgment on a motion to the pleadings or a summary judgment motion that's written in an incredibly fact-specific way for one case that no one could really rely on. And you've got these Southern District judges who all think they're the biggest swinging Richard in the courtroom, and they want to show the other judge that they don't agree with them exactly. I think at some point we're going to get something going really far in the other direction. I sat with Judge Hellerstein in a conference on a case, and, he said, I don't understand why when you put something up on social media, you haven't abandoned your copyright. Mr. Lebowitz, I think you should brief copyright abandonment in this case. Forget the license. I want to know if you've abandoned it. And I was thinking about that, and I hadn't really researched copyright abandonment too recently and briefed that issue. And then I went back to Goldman versus Breitbart, which was a case I was involved in for a client. And that's one of the ones that started a lot of the problems in the Southern District. And the same thing happened. Huge amounts of time on a motion, and then a decision that says one thing and hedges in 20 other directions, and then everybody settles. So it's just left hanging out there. But Judge Forrest said she thought there were genuine issues about whether plaintiff effectively released his image into the public domain when he posted to his Snapchat account.
I agree with everything you say, as Harry well knows, because we used to handle these together. I've defended very prominent media companies in scores of plaintiffs, I'll call them photo trolling bar cases. No client is going to want to spend hundreds of thousands of dollars to litigate it to try to, when you can get out of it for a few $1,000s or 20. But I have a fundamental question. And by the way, I assume, just for the record, everything we're all saying here, it has nothing to do or is tied to our clients, past, present, future. This is an academic discussion, right? So my fundamental question on that, which I never quite understood from the Ninth Circuit, how do you justify the server test with the statutory definition in the Copyright Act of what a display means, which is to show a copy of a work directly or by any other, either directly or by means of any other device or process. So how do you reconcile that statutory definition with this judicial made concept that I'm displaying a work, but it's not stored on my own
But
server?
I mean, well, I was going to say that the entity that publicly displays an image within the meaning of the Copyright Act is the entity that controls the means by which a particular copy is shown to the public. And so the only way that somebody can embed an image, if it is already publicly displayed with the copyright owner's authorization, the owner has placed it online for anyone to see at that exact location, and the embedding website is pointing viewers to that location. And if you turn embedding off, then you're not going to have content. So the question is, who is responsible for the display of the image? And in the Ninth Circuit's view, that is the one who controls the server that transmits the display.
But the problem I have, and I'm just being devil's advocate, and this goes back to your comment, Mark. So in social media, every platform, Facebook, YouTube, has license provisions in there, and that comes up in various cases. Some defendants have argued, well, I thought the license gave me a right to embed, and we find out, well, no, it doesn't do that. Only on the platform it gives you a right, and et cetera, et cetera. So there are a lot of nuances there. The platforms don't give third parties the right to take the content and display it, even though it's on the social media's platforms. Just saying, I think academically, it's a complex issue and doesn't jive well with the definition of a display right in the Copyright Act. And I'm happy to argue the other way.
I think that's what we saw in the Breitbart case and what they were saying, right? So, but let's, we are coming up on our time here, and I think we could have a whole series on this, and maybe we will invite everybody back because I feel like we only just scratched the surface. But I'd like to give everybody 30 to 60 seconds to kind of give some final thoughts on where you see the state of the current affairs and where things are going, and any parting words. So why don't we go ahead and start with James?
Yeah, thank you so much. I think anyone who litigates copyright cases, whether you're on the plaintiff side or the defense side dealing with alleged infringement, you have to look at the economics of these cases. I think the server test, while there could be avenues of mischief, I don't think that the solution is to throw the baby out with the bathwater. There's Rule 11. There is other avenues in which things can be pursued. But at the end of the day, I think we all want clarity, and I think advising our clients in terms of where you file cases, where you go to protect your rights, where you seek fair compensation always has to be measured by, are there willing lawyers to take on those cases, and is there going to be clarity either at the legislative level, or do you have to do it at the appellate level, which is very costly to get a single photo or a single case all the way through appeal and summary judgment in one. It's economically unfeasible, but I do think we all want clarity, and hopefully the Fifth Circuit maybe provides that. It's not the Second or the Ninth, it's the Fifth Circuit that does that.
Thank you, James. What about you, Mark? Final word on server?
No, I mean, I think it's an interesting issue. I represent both sides on cases like this, and the publishers I represent are not massive companies. They're small publishers. And I believe the server test is, in my opinion, it's a more reasonable and rational way to deal with the way technology works and the way publishing and inline linking works. And it also, I think, acknowledges the interests of the parties, in that the party who puts it up and affirmatively allows embedding and gets benefits from that shouldn't be able to pick and choose and just start suing some people with no takedown requirement. And I don't look at it as some judge-made law that flies in the face of the Copyright Act. I look at it as a rational way to look at the display factor with the way technology works. And I think it's good. It would make good law in the Second Circuit as well. And sorry, I know my time should be up. And if that's not the case, I think we need better law from the judges on how the express licenses in the terms of use work.
Thank you. Aaron?
Yeah, I mean, just thinking about the two topics, it's a bit of an interesting dichotomy because in the Ninth Circuit, there is kind of an easy off-ramp via the server test on cases that in the Second Circuit would end up turning on issues of, or at least in the Southern District of New York, many of the courts would turn on issues of fair use and implied license and other things that would drag out the litigation and increase costs. Whereas with respect to substantial similarity, you kind of have the opposite where at least recently judges here have been sending cases to trial all the way to jury trial after, 5 years of litigation, by all accounts, probably could have been decided on summary judgment, if not motion to dismiss. So I guess you have a little bit of each in terms of trying to be efficient. But I think to James's point, certainly the uncertainty and complexity is what makes it interesting and also, financially viable for everybody to be involved at this level.
And Barry, last word.
Yeah, so I definitely agree with what Aaron said. And the Second Circuit practitioner, I would love to see this Ninth Circuit dichotomy, intrinsic and extrinsic, kind of, changed into something that's a little more manageable, like we have in the Second Circuit. I think most circuits have a variation of the Second Circuit, but not making it so difficult and so impossible and economically so expensive in a case where, whether it's the court, where a court judges can't see works where they can readily compare them, textual works and art, and with limited intake from experts to make decisions on summary judgment or even motions to dismiss, which saves the parties, huge amounts of legal fees and will end this, East Coast, West Coast forum shopping.
Yeah, I mean, circuit splits, the need for clarity in the law, that's the reason why podcasts like this are so important. I just want to thank all of our panelists. This has been a dynamic discussion. I think I will recommend that we do a part 2 because I think we were just getting into it. So I want to thank you all again. Thank you to the New York City Bar Association, and thank you to all of our listeners.
Thank you for listening to this episode of the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar. If you enjoy this podcast, please like and subscribe wherever you listen. Find more City Bar podcasts on Apple, Spotify, YouTube Music, iHeart, or at our website at www.nycbar.org/podcasts. This podcast was produced and edited by Eli Cohen and Jalen Martin.